This annual conference was organized in presence for have a good point of the situation of your research. But the main topic of this annual conference is integration of the European policy and general the policy in your research. What is the connection and the relationship between policy and research in the scientific sector like yours, that is in the integration between technologies and law and science? So the main goal of today is to thinking about policies, soft law, and how to orient, how to use, how to integrate policy, specifically European policies in your research, and how you could help the creation of policy in the European context. So for this reason, I have the honor to have two great panels today, one dedicated to data, but also artificial intelligence, and the second one after the coffee break dedicated to the healthcare. Let me say also that let me thank the organization of the Catholic University of Leuven for hosting us. And let me also say that Anton Vedder, unfortunately, can join to us for health problems. But he is in spirit here with us for following your research and the conference. The second information that I would like to give you is the second panel is reorganized due to the COVID infection. Some speakers not available in presence for this reason, and the other are not available at all. So we have a new panelist. One is Giacomo De Federico from University of Bologna, expert of EU law, especially in health sector. And the other one is Giorgia Bincoletto here, now PhD, not PhD, postdoc fellow in the University of Trento and alumna of LAST-JD. And the last, Professor Fraser, University of Wales, online will be connected with us. So this is the panel of the day. And in the afternoon, we have a visit in European Parliament with a special visit dedicated only to us. And this is a great occasion also to have a contact with another piece of a European institution. So I recommend you to make questions and especially linked with your research. So this is a great occasion to have a dialogue with the institution. This is the intention that led the organization of the annual conference now that we are starting. So I invite now, I'm started to present the panelists of the section chaired by Professor Heinz Christian of the University of Hannover that is connected remotely. And let me present the panelists, Antonio Biason from the DG CNECT, especially from the data policy department. So please. And Christian, the floor is yours.
Yeah, thank you very much, Monica, for this kind introduction and, of course, for steering us through these troubled times with a clear hand and clear foresight. Thank you very much for that. Without further ado, I would like to hand over to the presenter. It's Antonio Biason from the European Commission. I think he will give us an introduction to, well, he is working for the European Commission in the unit data policy sorry for not being familiar with these technical terms. He's working in the DG CNECT in the unit data policy and innovation. He has, as far as I could see, studied at Kent in the United Kingdom and Portugal in Lisbon, and he will give us a very interesting and I think very timely presentation introducing the European data policy and all the exciting developments which are underway here. Without further ado, I give the word to you. Please enlighten us, Antonio.
Okay, yeah, it's working. Hello, everyone. Good morning. Indeed, my name is Antonio Biason, and today I'll be talking to you about these three big topics: EU Data Strategy, the Data Governance Act, and the Data Act. I think any one of these could merit a 20 to 25-minute presentation, so surely I will have to oversimplify things and gloss over, but I'm more than happy to engage here or bilaterally later so we can talk a little bit about more these topics. And also, knowing my audience, surely there's some topics that you know already, but nonetheless, I hope that you can take home some new insights that I'll mention today and share with you. So next slide, please. So the Commission sees data as really one of the biggest priorities for this mandate, which started in 2019. And the reason for this is that data is one of the key resources to really drive the 21st century economy, but also making sure that people have more knowledge about their own personal, well, their own personal lifestyle, for instance. The value of data is, of course, immense. Think about the potential that data can have in terms of the development of personalized medicine that really is aware of the needs that you have in terms of specific diseases that you might have, or think about in a larger context where data can be used for improving mobility in a city, or perhaps even thinking about the reduction of environmental impacts. So the reason why the Commission started investing and developing its ideas in this field was because this is such a field that has a multiplying effect throughout different sectors. And also, very importantly, is the fact that the current business models around data are not aligned with the European rules and values, really. So the reason why we started investing and developing such policies was precisely this one. Now, if we do not act now, if we don't take the opportunity to start developing such fields really as a matter of urgency, we will be lagged or inhibited by such higher transaction costs of data sharing, or really making sure that we need to make sure that we have sufficient availability of data to make sure that all of the different, or the previous examples that I gave, and many more, of course, are made possible. And we also have to act at the EU level, because otherwise member states will start developing their own regulatory frameworks which might not be interoperable. So what happens, or what is possible maybe here in Belgium might not be possible in Spain. So we really want to make sure that we build this single market for data that is open and also sovereign. So in this sense, sovereign means that we are able to define the rules that are that we want to follow, the rules that are applicable to us and according to our values. And next slide, please. So in February of 2020, the Commission adopted the European Strategy for Data. And what the vision is essentially that we want to have data flowing freely between sectors, between countries, in line with these European rules and values. We want ample amount of data. And also we want to ensure that the rules to access and use such data are clear and fair. To do that, the European data strategy will be deployed across these 4 pillars. Now, of course, we want cross-sectoral rules regarding the access and use of such data, and I will go a little bit more into that later on. The Commission is also investing massively in the development of and the building of data infrastructure. Competences is extremely important pillar, because we might have the data, and there is already a fair share of data around, but if people do not know how to use such data, it will be all, well, useless or worthless. So, and this, even in competences, we have two elements. We want to empower individuals so that they have the rights to use that data, but we also want to provide these individuals with skills and tools so that their empowerment is actually, let's say, enforceable. And also very important in the context of the digital decades targets, where we want to have 20 million ICT experts by 2030. And finally, the rollout of common European data spaces, which perhaps some of you have already heard, and I will talk a lot about them as well in just a second. Next slide, please. Quite often the Commission is asked why another legislation, meaning the Data Act that has just been proposed. Why do we have, are we really sure that we want to add, quote unquote, further complexity to the corpus of legislation and data? And so this slide and the next two slides will aim to show that there is logic to what we're doing. There is a plan, and it really aims to marry these different elements. So very cross-sectoral legislation, investments in the building of infrastructure, and also this very important aspect of the data spaces. Not yet, please. So yeah, this slide. So what are we looking at here? The different aims of the legislation. So on the far left side, you would see the opening up of data. So of course, the Open Data Directive that entered into force in 2019, that is its main objective. On the other end, we have the DMA, the Digital Markets Act, whose main aim is indeed correcting market imbalances. The DGA, so the Data Governance Act, and the Data Act are more or less in the middle. The GDPR and the free flow of data regulation, these are slightly in a different category because they are aiming at ensuring data protection, but also the free flow of personal and non-personal data. Next slide, please. So this slide. So first we saw the aim and how the different pieces of legislation are looking at different objectives. And when we're talking about the different types of data, what do the different legislations touch upon? So again, on the far left, we see the GDPR that deals exclusively with with personal data. And on the other end, we see the free flow of data regulation dealing exclusively with non-personal data. And then the DMA, which deals with mostly personal data from the private sector. And in this regard, the Data Act deals with private sector data, but both personal and non-personal data, which is really a key element here. Next slide, please. And now finally, regulated actors. What do the different proposals regulate, or who do they regulate? So we see that the DGA deals with data intermediaries, so essentially the organizations that aim to bring together those who seek data and those who have the data. And then the DGA also regulates public sector bodies, but really the focus here should be on the Data Act, because it's the topic of today's talk, but also seeing that it touches on a range of different actors, including, well, gatekeepers, or there's a specific chapter in the Data Act dealing with cloud and edge providers, and, well, other businesses as well, because it's a regulation that touches upon quite a lot on business-to-business relations. Next slide, please. And so I promised to talk a little bit about common European data spaces. So data spaces are essentially, they bring together data governance and the technical infrastructure to allow the sharing of data in a certain space. The objective of the European Commission is to have a single common European data space, which would mean that all of the different data spaces that you see above, and possibly more, because this is not an exhaustive list, there can be many more data spaces, but we want all of these to be interconnected so that data that is, for example, generated in the energy sector can be used in the industrial and manufacturing sector. There should be really no prevention or prohibition for such intersectoral use of data. Really, that is the potential that data brings us. And the Commission will also be investing in the development. They will build this data spaces support center, which will help the development of these common European data spaces. And the Commission will also procure and make available this technical infrastructure that will lay at the base of the common European data spaces. Next slide, please. Okay, so now looking, we've dealt with the EU data strategy, so the broad overview, and now we're going to look at the Data Governance Act and then the Data Act. So the main aim of the Data Governance Act is to increase trust in data sharing mechanisms, and specifically dealing, the Data Governance Act, the DGA, deals mostly with voluntary data sharing. So it's divided in these 4 pillars, which we will go one by one. So maybe we can just move on to the next slide. So the first pillar, the Data Governance Act, is dealing with data that is currently held by public sector bodies that cannot be made available as open data. For instance, such data would be protected by the rights of third parties. So this would be, for example, trade secrets or confidential business information or data that is protected by intellectual property rights. And so the Data Governance Act says that if there are member state legislation or union legislation that allows the reuse of such protected data, it has to be done in a harmonized way across the union and subject to conditions. These conditions might be, for instance, the public sector body making available to a potential reuser a secure processing environment where the reuser will be bringing their algorithm to the data without the data actually being disclosed or exported somewhere else. So really making sure that the reuser is able to extract the knowledge from the data without seeing the data. And this is a technical condition, but there might be also there is also the possibility for contractual liability. So the reuser would be contractually bound to certain reuse of that data. And in this pillar, the member states have a lot of, let's say, freedom to choose how and when they want to make such data available, because it shouldn't be made available just because you want to. It has to be made sure that the data is disclosed in the right way or reused in the right way. But the member states will all have to designate at least one single information point. So this means that there might be more. There might be one single information point per sector as well. So where the reusers will be contacting these single information points and saying, oh, I want to use data related to the mobility data in Leuven, for instance. And then the single information point would say, fair enough, try and contact this public sector body. So really making sure that there is a chain here where the potential reusers of data know where to find interesting data for them. So this pillar, more data, not less data. The second pillar is quite crucial because it regulates a new and novel type of actor in the market, which would be this neutral data intermediary for business to business and also business to consumer to business relations. And this is an element that will be very important in the construction of the common European data spaces, because they cannot monetize the data that is flowing through them. So if you remember earlier when I mentioned that data intermediaries will be essentially bringing together the people who have the data and the people who seek the data. And this is really a key element in the professionalization of trusted data exchange. And really the only thing that they have to do, so it's in terms of admin or compliance with such measure, would be to notify the competent authority in a member state before entering, before functioning. And quite the policy challenge in this regard will be, of course, to understand how exactly to deal with issues of data protection, for instance. But this is a field that will be evolving and one that these types of actors will be very crucial to make the difference towards other types of governance around data that we see around the world. So this one will really make sure that people can trust the intermediaries to which they will be providing their data to. Next slide, please. Currently in the European Union, we have quite the fragmented approach when we're talking about, for instance, let's say that I would go to a doctor and I would want to make the data that has been collected about me during that visit, I want to make that available for free, voluntarily to a research institution. And currently there isn't really a EU-wide framework that will make such that will allow with clarity the mechanism for how I would make that data available. There are, of course, examples of organizations that engage in this, but it's a nascent field. And this third pillar of the DGA essentially provides the possibility for such organizations to voluntarily register themselves with this label, which will be the Data Altruism Organization recognized in the Union. And so this doesn't mean that everyone has to do it or every single data altruism organization would have to do it. But if they so did, then if I would go to the doctor and see that there's a possibility for me to quote unquote donate, which is the wrong term because donate doesn't imply also the possibility to withdraw the consent, right? So, so quote unquote. And these data altruism organizations would allow for such mechanisms to be possible, or even my rights to be enforceable in that way. So next slide, please. And finally, the fourth pillar would be the European Data European Data Innovation Board, which essentially will advise and assist the Commission in developing guidelines and developing proper governance of technical standardization, for instance, really to facilitate more data sharing, as well as facilitating the work of the different entities that I have been mentioning. Yes, please. How am I on time? I'm okay? Okay, good.
You're okay.
Good. Okay, so now let's move on to the Data Act. The Data Act very shortly aims to do the following. It will try to regulate who can use what data and under which conditions. The Data Act is essentially focusing on this, ensuring that there is fairness in the allocation of value that is generated by data in the economy, because currently we know that there are multiple situations where the manufacturer of an IoT object, for instance, will have the unilateral or exclusive control over the data that is generated by that product. Let's say that I have a dishwasher or a smart fridge or any kind of home appliance, really, and I want to send that data or share that data from the fridge directly with a repair and maintenance provider, for instance. Right now, that isn't possible, that there is no legal mechanism to ensure that I can do that, although the dishwasher is mine. So this is quite an unfair situation if you think about it. Or there are of course many other examples, but not to digress too much on the different examples here. The Data Act will also aim at unlocking the value of data coming from industrial data, which is really massive, and it should be as Commissioner Breton for the Commissioner for the Internal Market says quite frequently, is all about the taking advantage of the second wave of innovation coming from personal data. Oh, from non-personal data, and this would be so at the same time, we want to ensure that the manufacturers that I was talking about before, that they have they still remain and still preserve the incentives to continue investing in the generation of data. And finally, of course, we would like the European Union to become a global leader when it comes to the data economy. Next slide, please. This is an overview of the Data Act and the different elements that the Data Act touches upon. So there's a lot of focus on IoT data. There is also provisions regarding contractual unfairness, and especially specifically in business-to-business relationships. The Data Act also touches on making sure that business data is made available for the common good, and this easier switching between cloud and edge services, and the facilitation of data flows through technical standards and interoperability. This is just an overview of the next 5 slides, essentially. Please. So I talked a little bit about what the IoT context in which we live in today is, and it's essentially the one that you see here. IoT is a novel type of technology, and it really challenges our presumptions around fairness, around the allocation or the distribution of data. And so with the Data Act, next please. With the Data Act, we are putting in place rules so that the user can have specific rights, and upon its request, it can request the manufacturer to share the data that has been generated by the IoT object with a third party to the benefit of the user. So this is really making sure that there is more data flowing, and specifically in the IoT context. Next slide, please. The Data Act also lays down rules that will be applicable across all different sectors. So the same schematics or the same framework around the IoT data rules will be applicable elsewhere. And this means that, well, if there is a legal obligation to make data available, then there have to be at least these 2 conditions. First of all, the making of data available has to be fair and non-discriminatory between different potential third parties, for instance, that the manufacturer would be sharing the user's data with. And also, quite importantly, that when I mentioned that we want to ensure that we safeguard the incentives for the continued investment in the development of IoT objects, for instance, the data holder may request a reasonable compensation from the data recipient. And very importantly, the Data Act is really an SME instrument. And this means that there are multiple provisions here, which I will also talk about soon, that deal with ensuring that we are giving data to those who need it. So we do not want to enrich the data rich. We really want to make sure that we have a level playing field in terms of providing SMEs who very much need data to be able to compete in today's economy. So for instance, there is this specific point here that SMEs cannot be requested to pay more than the direct costs for making data available. If you are a larger company and you are getting data, then you will be able to negotiate negotiate a reasonable compensation to be provided to the data holder. And this leads me to the unfairness test for business-to-business contracts. And the golden rule is the one that you see above. It says essentially that unfair contractual terms unilaterally imposed on a micro, small, or medium-sized enterprise are non-binding. So this means essentially that we want to move from a situation that you see in the red box, where the larger company just imposes certain terms on the SME regarding data sharing. And these terms have to be, well, they are either presumed unfair, or they would be deemed unfair by a competent authority or a court. So we want to move from the red box situation to the green box situation, where there is an actual negotiation between the 2 parties, from the larger party and the SME. And an unfair term would be, for instance, obliging unreasonably short termination periods, for instance, or making sure that there is this exclusion or limited liability on the party that is imposing the terms, and many more. And the Commission will be developing these module contractual terms that will be helping ensure that we have a fair and balanced negotiation, or really contract terms between the two. Quite importantly is the fact that if there are unfair contractual terms regarding data sharing in a contract, that does not mean that the entire contract is not applicable. It will be those specific terms that will have to be reconsidered. The Data Act also deals with business to government data sharing. So this means essentially, well, the pandemic is a very clear example of a situation where suddenly there was an urgent and dire need for the public sector bodies to make sure that they had the best means possible to provide better public services. So in this situation, the mechanism in the Data Act would have been very useful. So this means that the public sector body would be requesting data from the private sector body based on an exceptional need. So we're really thinking about health crisis, a cybersecurity attack, something that is that then the public sector body would have to demonstrate. So they would have to comply with proportionality and justification, and they would have to really make sure that this provision of data does not it's not meant to be used as if it was a reporting obligation on the side of the private sector. So on one hand, we have the public sector bodies making or having better data at the right time. And at the same time, the Data Act has a mechanism so that the private sector, for example, in the situation of the pandemic, is very easy. They won't be bombarded by public sector bodies across the union requesting access to their data. So there is a mechanism in the Data Act that ensures that there's that it complies with the once only principle, so that when a private sector body is has provided access to their data once, they don't have to do so more again. So it really streamlines this procedure. Yeah, next slide. Thank you. And the final slides and the final chapters of the Data Act deal with improving trust in and performance of data processing services. So this is cloud and edge providers, and we want to avoid situations where there is a vendor lock-in. So as soon as you start engaging with a specific cloud service provider, for instance, and then it's quite difficult, if not impossible, to change to another provider of the same service. So the Data Act allows for the removal of obstacles between switching of different cloud providers and edge providers as well. And then we also implement or adopt certain safeguards to ensure that in situations where there are unlawful access requests to non-personal data that is held by cloud and edge service providers in the union, there are safeguards that prevent that transfer of data if such access requests are unlawful again. And then the Commission will also be empowered to adopt implementing acts where it sees that there is lack of standardization in a specific sector or in a specific, well, I think sector actually would be the most correct term. And so yes, this will be also facilitating data sharing in the context of data spaces, of course. And next slide. And so this is just really the conclusion slide about what we aim for the Data Act to change. We talked about the potential of the EU's industrial data. We talked a little bit about as well the empowerment of individuals and companies. So giving the possibility for us consumers, but companies as well, to make use of the data that is generated by their products. With the Data Act, there will also be an improvement in the delivery of public services because the public sector will have the right data at the right time. And then also this facilitation of the switching for cloud users. And that would be the next slide. And that would be it from my side. Thank you very much for your attention.
Well, thank you very much.